What happens during jury selection in a Texas criminal trial? Jury trials in Texas criminal trials take two forms, those that are in misdemeanor cases and those that are in felony cases. In a misdemeanor case, you will have 6 jurors who determine whether or not a person is guilty of an offense, and if the issue is submitted to the jury, what the appropriate punishment should be. And that's unique to Texas. Most states don't have jury punishment if we get to a punishment phase. In most states and most jurisdictions, you see that only judges have the ability to impose punishment. Felony trials are similar, except we have 12 jurors on felony juries instead of 6. Jury selection begins with the process of the summons. So a number of summons are sent out by the county to residents of the county, typically based on individuals who have driver's licenses within that county. So you'll receive a jury summons typically in the mail. You will respond to that summons. In Tarrant County, many of those summons call for you to fill out an online form if you're able to. And that'll give both the attorneys and the judge some information about you before you even show up in court. In a misdemeanor case, that summons will result in somewhere between 18 and 24 people being called into a room for the jury selection process. In a felony case, you might have some number between 60 to 75 or even 90 jurors who are called into one courtroom to serve as potential jurors. These folks have not become actual jurors yet. They are simply potential jurors. From there, we begin the jury selection process. Typically, a judge will go over some basic tenets of the law. What are the rules that apply to jury selection? What do you have to do? And the first thing that you have to do as a potential juror is swear that you will give true answers to any questions that are presented to you. So then both sides, the prosecution first and then the defense attorney, will get a chance to ask you questions. And they're asking you questions to see if you would be a good juror on this case. Now, we use the word jury selection, but what's really happening is people are being disqualified and essentially unselected from the jury. So when you go into the courtroom and you're seated, you're going to be seated by juror number. The closer you are to the front of the courtroom, the greater likelihood there is that you will actually be seated on that jury. So what the attorneys are doing is asking you questions to see if you are qualified. The actual legal qualifications are pretty low threshold. Are you eligible to be a registered voter in the county, whether or not you've actually registered? So that covers citizenship, and that covers things like, well, you're not a convicted felon. So they're very basic tenets that have to be met in order for you to be qualified. But from there, the parties are asking you questions to see if you could be a fair juror on this particular case. So if on a DWI case, you say that you've had a close personal experience with intoxicated drivers, perhaps you've lost someone to an intoxicated driver or know someone who has, you may not be the best juror for that case. And you're entitled to say that. And the attorneys are trying to get at those types of feelings or thoughts you may have that make you less than ideal for that particular case. That's not to say you wouldn't be a good juror in any other type of case, but there are certain issues for all of us that would just be too sensitive for us to have to sit through days of a trial listening to. The attorneys are able to disqualify individuals who essentially say that that particular case is not one that they can be fair on. These are called challenges for cause. There's a separate way for attorneys to get rid of people from a potential jury, and that is what are called peremptory challenges. So in a misdemeanor, an attorney has 3 strikes. In a felony case, an attorney has 10 strikes. So these are strikes that can be used to take people out of being seated on the jury just based on the attorney's feelings. It can't be based on any sort of protected class. So you can't go and strike all the men or all the women or all the people of a certain ethnicity from your jury. But for any other reason, I didn't like the way he looked at me. He brought in a book that I didn't agree with. He was wearing a shirt that I didn't like or would be unfavorable for my client. Those are all valid reasons to strike someone using those peremptory strikes to get them off the list of potential jurors. So you have people who are disqualified. You have people that say they can't be fair. They're challenged for cause. You have people that are struck for no reason, as long as the reason is not a protected class of individuals that you are systematically getting rid of. And of course, there are other things that might lead a person not to be on a jury, which are called excuses. So for example, if you're the primary caregiver for a young child and there's no other person who could take care of that child, that is a legal excuse you could claim. Similarly, most judges will excuse you from jury service if you have a prepaid trip that is going to occur during the course of what would be the trial. There's a little bit of discretion there, but most judges will let you off potentially sitting on that jury if you have that type of a conflict. So what's happening is from that starting point of having 18 to 24 jurors or 60 to 90 jurors, the list is getting whittled down. From there, the first remaining 6 or the first remaining 12, if we're talking about a felony, individuals who are left after all those strikes, challenges for cause, excuses, the first 6 or first 12 become the jury. So if you come into the courtroom and you're sitting in the very back, the chances are you're not going to get reached unless so many people disqualify themselves or there's so many excuses that we're starting to get down to the very end. If after all the strikes and challenges are made, if there are not 6 people who can be seated on a misdemeanor or 12 on a felony, the panel has essentially busted. And the judge will have to reconvene another pool of jurors, potentially a larger pool, to try to seat a jury from that. And that does come up with some regularity, especially on cases that are concerning very sensitive matters. So if you have an accusation of a child sexual assault, that's the type of case where a judge might even preemptively bring in extra potential jurors just because they know historically a lot of people are going to have strong feelings and perhaps not be able to sit on that type of a case. So that's how jury selection works in Texas. If you're curious about how not to serve on a jury in Texas, check out the link below. We've done a video on how to avoid jury service in Texas. And once you've seen the video, you'll understand why we have an answer to that question. We're making these videos in response to questions that we've received here on our YouTube channel or through our website. So drop a question below if you have any question regarding criminal law in Texas or federal criminal law, and check out our website, versestexas.com.